If you're accused of a misdemeanor in Massachusetts and you haven't been arrested, generally you're entitled to a clerk magistrate hearing. Sometimes even for felony cases, the police won't arrest you but rather summons you for a clerk magistrate hearing rather than arraignment. The purpose of a clerk magistrate hearing is to determine whether or not there's probable cause to charge you with a crime. So prior to officially being charged, you go into a room where it's you, your attorney if you hire one, the police officer who wrote the report or a representative from that department, and the clerk magistrate who ultimately decides whether or not you're charged. These hearings are conducted in private, they're not in open court, and they're done in such a way that the rules of evidence don't apply. Sometimes I'm contesting probable cause, sometimes I'm advancing legal arguments, but more often it's not about the actual probable cause. More often, the point of these hearings is to try to convince the clerk magistrate that justice would not be served with you being charged. A lot of my clients in this situation have never been charged with a crime. They're people that ended up in a bad situation or maybe made a bad decision that day, but it doesn't represent who they are as a person. Oftentimes, I'm able to convince the clerk magistrate not to issue the complaint. Either they can dismiss it outright or hold it open for a period of time, in which case you stay out of trouble for that period of time and then the case gets dismissed. If the case is either held open and dismissed or dismissed right away, that means it'll never appear on your record and you can truthfully say that you've never been charged with a crime. So these clerk's hearings are very important. You're not entitled to an attorney here, so you don't get somebody appointed. You'd have to hire one. I'll tell you why it's important to have one. If you go in by yourself, you have to say something. You have to talk. You may admit to something even if you don't mean to. Your words can get twisted around. You're going to be under oath. If you have an attorney with you, you don't have to say anything. Generally, when I'm representing a client at a clerk magistrate hearing, I do all of the talking on behalf of the client. I talk about what the client has told me. I can make representations at these hearings. I can explain what that person's done in their life. I can give some background information about the person. I can provide context to the situation, try to explain why that person ended up in the situation that day. And then I can argue to the clerk why he or she should not issue the complaint. With an attorney, you're protecting yourself, not only giving yourself the best chance to try to avoid a charge, but also in the event of a charge, you're not locking in your testimony under oath, which could really hurt your case if you end up being charged.